All right, in Chapter 13, we're going to zero in on the 14th Amendment, equal protection, and we're going to look specifically at female offenders and other offenders. The chapter looks at what may be described as the non-discrimination requirement of the Constitution. 11.5% of the population of state and federal adult correctional agencies are female offenders. Most states only have one correctional facility for women. Difference in number between men and women inmates led to many of the complaints against disparate treatment for women. In Bakari versus Hutto, the district court had complaints from female inmates they were being treated differently and more poorly than men. Virginia had just one facility, fewer programs for women. The district court held the state would have to justify its reason for treating women inmates separately and differently from men. The Equal Protection Clause requires a parity of treatment for women, but not identical treatment. In Batten versus State Government of North Carolina, female inmates claimed they were being sent from all over the state to one prison. Claims made by the district court included these that are listed here. District court noted the women were only 4% of 15,000 state inmates at the time. To evaluate the women's constitutional claims of disparate treatment, the court took the standard from the Supreme Court decision of Craig v. Bourne, a non-prison case. To withstand constitutional challenges, the classification by gender must be classified or justified by important governmental objective and be substantially related to achieving those objectives. District Court in Batten accepted the state's justification for disparate treatment in some areas, like medical and psychiatric care, disparate wages, law library, required development of further evidence in other areas, parole, work release, those type of things, to determine that there was a substantial relationship between the reason for those female programs and the achievement of a legitimate governmental objective. In Glover v. Johnson, a federal court held that the educational and vocational programs in Michigan were markedly poor for female inmates, denying them equal protection in order that a substantially equivalent program be established. In Park v. Thompson, the federal court held it was unconstitutional for Hawaii to not have any long-term facilities for women. It held it was an equal protection violation to have such facilities in the state for men but not for women. In Pitts v. Thornburg, Court of Appeals affirmed a lower court ruling that there was no violation of constitutional rights by transferring female inmates out of the D.C. or District of Columbia while allowing men to stay closer to home. The trial court held transfers caused no violation of constitutional rights because there was no showing the facilities or programs at the female facility were of lower quality than the males. Appeals court affirmed finding transfers based on important governmental objective, which was relieve severe overcrowding in D.C. prisons. In Jackson v. Thornburg, again, the issue was the D.C. or Good Time Credits Act. Its provision for early release to reduce overcrowding in D.C. prisons. Female inmates sent to a federal prison outside D.C. sued as the transfer made them ineligible for the Act's provision. A challenge was made in equal protection grounds, claiming in part an unlawful gender discrimination. The appeals court denied the claim, holding the act distinctly was not based on gender, either overtly or covertly. In Muller v. Gates, county jail provided minimum security status and facilities for male inmates, but not for females. All females were treated alike, but they were that meant no minimum security privileges for women. One example, male inmates could have contact visits, female inmates could not. Lower court found this to be unconstitutional, violating equal protection laws of both the state and federal government. But in Morrow, the federal appeals court upheld a court's or county's jail visiting program allowed more visitation for male than females. Appeals court held this was justified as jail had many more male than female inmates and found no violation of equal protection. In terms of non-citizens or foreign offenders, the Fourth Amendment says it protects persons, not just citizens. There are court rulings, however, that have held that persons entering the U.S. illegally are not protected by some constitutional provisions. They're considered excludable aliens. Some courts have given protections to non-citizens or foreign-born inmates, for example, prison mail case discussed in Chapter 7. Other equal protection cases, male inmates may also raise equal protection claims, not just women. In Hill v. Estelle, 6 Texas male inmates brought a 1983 action against prison system. In part, male inmates objected to female inmates being allowed to have long hair while the males could not. Females could call families, males could not. Females and like males were allowed to decorate their cells. Appeals court conceded disparate treatment but held there was no constitutional violation. Main point, in order to justify different treatment, there must be a substantial government or correctional reason. In terms of racial discrimination, the Supreme Court has yet to address equal protection for inmates, except in the case of racial discrimination. Lee v. Washington upheld the lower court opinion that in isolated instances the temporary segregation of race might be okay.